Hello, everyone, and thank you all for joining today. My name is Alex. I'm the co-CEO of PageVault, which is a software and services company that's focused on online evidence collection and preservation for the legal industry. My intent for this webinar today is to be helpful for attorneys, paralegals, investigators, legal support professionals across firms, law firms of all sizes, legal service providers, governments, and in-house legal teams. I'd especially like to thank those who contributed to inform the content through interviews and through some of our previous webinars, including attorneys and legal support professionals from Latham and Watkins, Greenberg Traurig, Fisher Phillips, Banner Whitcoff, Barrick Ferrazzano, Stokes Lawrence, and the Department of Justice. So we will get into it. Let me share my screen so that everybody can follow along as we run through the content today. Great. So quick agenda for today. We're first going to talk about the rules of online evidence generally, what it is, why it's important, and some use cases across different types of law. Then we'll cover the rules that govern this online evidence collection and cover some relevant case law as well. Finally, we'll discuss different approaches to online evidence collection as well as some best practices. So we'll start with the overview of online evidence. Really, what is it? And we think about the world of ESI, electronically stored information, in two main buckets. That's data types that are primarily private and data types that are primarily public. The private data world is where the vast majority of attention in e-discovery tends to get placed. And so this includes things like email, Office 365, Teams, cell phone data collection, and this is classic e-discovery. Both sides are obligated to package up all this relevant information, their first-party data, if you will, and then exchange that with the other side, which then gets processed and reviewed. And of course, there's a lot of different tools and vendors out there who are helping with this process. Public data is really everything that exists publicly on the internet, and so that includes things like websites, social media accounts, videos and media files. And whether we call this public data or third-party data, this is where you're actually going out yourself and collecting information that's been made available by the other side or other parties that's now publicly on the internet. And I'd argue that this is often overlooked in classic e-discovery processes because it just kind of feels easy by comparison. It's all sitting there on the internet. Why would we even need to collect this? And so I think the feeling of simplicity here is actually deceptive and has been holding the industry as a whole back from proper collections of public data. And so that's going to be our focus for today. And we'll explain why we believe the strategy here needs to be just as intentional as the strategy that we've seen get built over the last decades for kind of the private world of ESI. So unfortunately, not only does public data require a strategy, but it requires a pretty different one from private data. And we have a couple of reasons here why that is, and then what the implications of those reasons are. First, and maybe foremost, the ball is in your court much more with public data. With private data, it's nice because you just kind of sit back and wait for a big package of data to come in from the other side. Of course, it's difficult to review it, but this data is kind of just getting handed to you. The flip side of that is you're a bit at the mercy of the opposing side and what they decide to produce. They're going to produce what they want to on the timelines that they want to follow, and you'll push them as hard as you can, but you're more or less at their mercy. With public data, no one is producing this data for you. The ball is in your court to go out, get this evidence, and use it strategically to your advantage. And so what that inevitably means is not everybody out there does it. Really, the attorneys, the law firms that want to distinguish themselves, they want to create a better strategy and create better outcomes for their clients. Those are the ones who are going above and beyond and differentiating themselves by proactively collecting this online public data. Secondly, the internet is dynamic. And so deleted emails can be recovered off of a hard drive, but it's generally quite a bit tougher to recover old versions of a website or recover a deleted Facebook post without a costly subpoena to Meta that probably isn't going to go through. So not only do you have to go get public data proactively, but you have to do it early and you have to do it often. This often comes up even before the case really gets going, before the litigation begins, because if there's something particularly useful to you on a public site, odds are high it's probably going to come down as soon as that litigation gets filed and somebody knows they're entering litigation. And so collecting relevant material as early as you can in the process, really as soon as you've done that initial research investigation, you have identified it, is critically important. And then finally, because public data is something you're going out and getting, you're collecting third-party data, the other side can always challenge how you got that. And so, interestingly, the bar is actually higher for the authentication of public data than it might be for private data, where a first party is producing that evidence for you. So we'll talk about authentication rules in a lot more detail today, but major implication there is you just need to be really careful with how you're collecting and preserving to avoid getting into some pretty costly trouble. All right, we'll take a step back for a second here and talk about just some common use cases for online evidence. I think it's helpful just to, for those who might not be dealing with it on an everyday basis, those of you who are, what your use case is. Those of you who aren't, or maybe you're in a practice support department and you don't necessarily see it all day, every day. Helpful to know what types of cases, what types of practice areas where we see this come up all the time. So, really integral to kind of case team strategy across different practice areas and departments. But we've highlighted, 9 or 10 here that seem to come up particularly often: intellectual property, labor and employment, litigation, general commercial litigation broadly, insurance defense, family law, investigations and criminal is a big interesting pocket in and of itself. Defamation lawsuits, pro bono work, jury and witness research, and there's probably a lot more, but these are some of the big ones. And then, a statistic here: an estimated 500,000 litigation matters over the last 12 months involved some sort of social media evidence. So social media is, of course, just one pocket of the entire world of public data that we're talking about, but it's a big one and it's growing and it's really here to stay. And so firms are realizing the importance of this and developing a strategy pretty quickly around this type of data. To dive a little bit deeper on a couple of these practice areas, intellectual property. So, brand protection, for example, a big part of most IT practices, whether that be trademark and copyright infringement, brand protection broadly. And so that includes things like, filing cease and desist for trademark and copyright infringement, all the way up until litigation. And so, for example, a firm who represented Snap Incorporated is actively fighting a woman who's consistently selling merchandise on her website and social media with pretty blatant infringement of the Snap logo. And so they'll take monthly screen captures of all her various sites as they work to build up their case. False claims is another big one. And so a story example here, there was a champagne brand who falsely claimed on Twitter that they were the #1 champagne brand in the world. Those tweets were deleted the next day, but luckily the other side had already captured them in the proper way. And so they were able to use those false claim tweets as part of the resulting litigation. And then wanted to call out, we'll talk a lot about litigation evidence today, but, it is not always litigation where, online content is relevant for law firms and for legal practices. It's also very relevant on the prosecution side in intellectual property. And so trademark prosecution, as an example here, there's these large firms who represent large trademark portfolios, and you have to actively go out and collect specimens for the initial filing of the trademark, for any renewal. And those specimen collections are essentially, 9 times out of 10, screenshots of websites. Those can be pretty time consuming, especially when you factor in, the requirements by the USPTO that you have to include a date and a timestamp on every page. And so having something in your arsenal that can help make that process easier is a lot better than going out and doing simple screenshots of those specimens. So it comes up across litigation, but also prosecution as well. Labor and employment, another large category of practice area of law. A couple of examples here, really comes up across the board, but often in employer versus employee litigation disputes for the most part. And so, there was a case where a firm captured social media posts to prove that an employee had actually faked an absence to attend a concert. There were captured social media posts showing somebody in the gym a day after filing a workplace injury claim that their back was, hurt beyond repair. And then there was a contract dispute between, a Major League Baseball and a player. And really this case turned on whether the player had an injury, with the player claiming that he wasn't injured. And unfortunately for the player, his wife posted some of his x-rays on her blog, which showed the injury pretty clearly. And although the wife removed the blog a day later, the law firm had actually moved pretty quickly to capture that evidence and was able to use that captured evidence to force a quick settlement. Litigation, general litigation broadly, comes up very frequently. Class action, particular example here, tend to be very large projects that require a lot of online evidence collection. And so firms will actually go in and capture full social media profiles, whether that be LinkedIn, Facebook, and so on, of all the named plaintiffs in the case, just in case there's any relevant information that could be popping up publicly as the case progresses. A couple of specific examples here. One, the Remington gun manufacturer case a couple of years ago. A firm wanted to capture all of their website, social media, anything public facing, as the case was about Remington's marketing practices to consumers and whether that violated the Connecticut Consumer Protection Law. Another example here where the outcome of a commercial litigation case hinged on whether or not the defendant in the case could speak English. In a deposition, he insisted he could not. However, there was a YouTube video that showed the defendant preaching in church in English, which actually ended up being the smoking gun in that case. And then finally, I wanted to call out pro bono, obviously a very important area of the law for a lot of firms, a lot of organizations who are doing great things in the world. And so, a couple of examples to call out: in a domestic abuse case, the firm's client had set up a Ring security camera and posted, a live stream video of that security footage online. And so while the video evidence itself was, fairly compelling, the abuser had actually then posted a string of pretty damning comments in response to that video post. And so the firm was able to go ahead and capture both the video and the comments and quickly sealed the case using that online evidence. It's also commonly seen as important in sexual exploitation cases. And so there was a whole documentary on Netflix recently called Money Shot, which was about how the company Pornhub was failing to properly monitor and remove things like underage porn and revenge porn from their site. An attorney in the documentary in that video is shown using Page Vault actually to collect the evidence needed to make her case. And it's particularly exciting that one of those cases is on the short list to be heard by the Supreme Court, and online evidence is really the entire exhibit package that is being used in that case. So just a couple of examples there to show the broad relevance of online evidence, why it's important to collect properly. And so on that note, we'll start to get into some of those relevant rules dictating how online evidence should be handled. And remember, this is important because you are actively going out and collecting third-party information, could potentially be faked, photoshopped, all of that type of things. And so how do we ensure that this evidence can be used and admitted in court, in depositions, anywhere where this type of evidence might be useful? So a lot of this comes from the federal rules of evidence, Rule 901 and 902, which dictate how an online collection can be authenticated. And so historically under Rule 901, somebody could establish authenticity by describing a process or a system and showing that it produces an accurate result. And this would generally require the testimony of a live witness to come to court, sit on the stand, and describe that collection process. As the prevalence of digital evidence grew pretty dramatically over the last decade, this got to be expensive. It got to be a pain. And so in 2017, the rule was amended with FRE 902, which says that many types of ESI were actually self-authenticating. And so if you could produce a record generated by a process or a system that produces an accurate result, that type of data could be self-authenticating. You wouldn't actually have to send somebody to go sit there and testify in court. And so now, instead of a live testimony, a capture can be authenticated simply by a certification of a qualified person. Somebody can write an affidavit, and as long as they provide the information that would be asked of them during a live testimony, that would be sufficient to have this evidence be authenticated and ruled admissible in court. And so affidavits obviously pretty critically important to this whole process, especially under the revised rule of FRE 902. And so to talk a little bit about what information needs to be provided in that affidavit to effectively authenticate a piece of evidence, there are two main components here. One is information about the process, which is otherwise known as metadata. And so that's things like the exact date and time that the capture was made, the time the site was served, the URL, the browser used, hash values underlying that capture. So a lot of very detailed information that are, often not easy to collect. Secondly, you need the certification of a qualified person. And that person is essentially saying, yes, I captured this evidence properly. I can attest to all of that metadata that we included in the affidavit here. And most importantly, I didn't then tamper with this evidence in any way. This is an original. This is exactly what I was seeing when I looked online and found this piece of evidence. And so there's a couple of different ways that you can get that certification from the qualified person, but fundamentally it comes down to the qualified person is the person who is in the digital chain of custody. And so if 7 people touch that piece of evidence across the digital chain of custody, all 7 of them would technically need to provide an affidavit. And so there are 3 big categories of folks who are often the ones writing and providing these affidavits. One, and the most common, is the collecting employee. And so often law firms will go in, they'll have a paralegal, they'll have a e-discovery professional go in and take screenshots of this evidence themselves. That person is now in the chain of custody. They are the collecting employee, and they're going to be the one who has to write the affidavit. Sometimes firms will decide to outsource the collection to a third-party vendor. Then that third-party vendor can be considered the one who's in the chain of custody. They actually did the evidence collection, and so they can provide that affidavit back to the law firm, which can properly authenticate the evidence. And then finally, there are tools, software tools that are self-authenticating and actually keep the user out of the chain of custody. And the producers of those software tools can be the ones to provide affidavits as well. And so we'll talk more about that in a few moments. And I think useful just to think about, what all of this means, because when we think about it in the physical evidence world, it's a bit more obvious. And so this parallels the logic for physical evidence very closely. Imagine we have a critical piece of evidence for a case, such as a thumbprint on a glass, a smoking gun, if you will. And then as an attorney, you took that evidence home to your office, you put it on the shelf, and then brought it into court with you a couple of months later. I'm pretty sure the opposing side would jump all over that. The judge would look at you like you're crazy, and you'd be like, you just completely messed up that process. That's not at all what we need to do here. We need to give that critical piece of evidence to a trusted third party, like a police officer. They need to go store that securely in a vault where no one's going to have any access to it or ability to tamper with that evidence. And then that needs to get brought in by that same trusted third party into court. But when people are out there taking screenshots of things that are on the internet, that's essentially what people are doing in the digital world. When they don't go take that screenshot, they save it down on their personal hard drive, and then they print that out and bring it into court. It is pretty crazy to think about if you think about that parallel to the physical evidence world. And so ideally, this web evidence that lives on the internet would be collected and kept secure in storage by some sort of trusted third party. Whether that be a vendor or a software tool that's built for this. The goal would be to, essentially have some sort of system to keep the law firm or, the person who's kind of most incentivized in this case, to keep those folks out of the chain of custody, reduce any distractions from the case itself. Some court opinions where online evidence was actually ruled inadmissible due to improper collection. So this is unfortunately much more common than you might think. And so we'll talk about a couple of examples here. But in the case Disney v. Sorelli, this is a trademark infringement case. where Disney was suing Sorelli for infringement of kind of characters like Mickey Mouse here. And most of their evidence was, of course, screenshots of Sorelli's website, of his social media accounts that he was using to promote his online party business. And the judge ruled that the plaintiff, Disney, relied on various pretty poor quality screenshots that have not been properly authenticated. And so that evidence is not admissible and cannot be considered for summary judgment here. Disney went on to lose this case largely because of this evidence that they weren't able to get admitted into court, kind of showing this trademark infringement. So a pretty embarrassing outcome for Disney and for their lawyers here. Commonwealth v. Mangel. This is actually a criminal case where the defendant posted a picture of bloody hands on Facebook, and the defendant was accused of a violent crime. And so, seems like it'd be pretty easy to tie those two together, bloody hands, shortly following the crime. But, because this evidence, again, was not corrected in the proper way, the evidence presented did not actually indicate the exact time that the posts and these messages were made on Facebook. And so the lack of that date and time stamp that's supposed to accompany all of online evidence that is collected and presented to the court, that raised a significant question for the judge regarding the actual connection in the temporal nature of the connection between those posts and the messages to the actual alleged incident. And so this evidence, which could have been, that smoking gun that they needed if it had been collected appropriately, was unfortunately, not able to be used as evidence against this crime. Two examples there, just showing two different types of cases, but the lists go on and on. This is just a subset of all the cases out there where some error in the way that online evidence was collected inappropriately resulted in that evidence being ruled inadmissible, resulted in that case going against the person who was improperly showing that evidence. And so high-level takeaway here, having firm employees in the chain of custody is really a risk that's not worth taking. In that Disney v. Sorelli example, for instance, the reason that evidence was not able to be admitted was because the screenshot person was in the chain of custody and they weren't able to provide the proper affidavit testifying to how that evidence was collected, proving to the court that it wasn't being tampered with in any way. And so anytime you're putting an employee in that chain of custody, you're opening up the entire case to risk. It's risky for the actual employee who's being asked to make that capture because they can be called on to take the stand and testify to how a capture was made. At best, this is pretty costly, it's annoying, and it's a distraction to the case. And it's likely not a risk that an employee at a law firm even knows they are taking, let alone wants to have to go through. It's also very risky for the attorney leading the case. Discovery-related errors, most commonly ESI-related errors these days, are the third most common cause of action for legal malpractice claims. And so these easily preventable blunders where you have the evidence you need and you just failed to collect it and authenticate it appropriately, these are just far too common and lead to some of these types of claims. And then finally, it's just risky for the law firm as a whole. This is huge reputational damage that happens if evidence gets thrown out of court and the case goes not the way the law firm wanted. And so, it's a preventable mistake, but it happens far too frequently. Okay, so moving on to our last section here, I want to talk a little bit about different approaches that different law firms, investigators use for online evidence collections. And then we'll recommend some best practices to avoid some of those costly mistakes that we just talked about. So the first approach that I'll give an overview here, we call it the ad hoc approach. And I think compared to classic e-discovery, this private first-party data exchange, like we talked about at the beginning of the session, compared to that, public data collection is just really not well managed at most law firms. And so an ad hoc collection process where every attorney and every case team is kind of left to fend for themselves is the most common approach. And so what do we mean by ad hoc? That's where there's no real firm-wide guidance or procedures given, and so that every attorney collects evidence their own way. It's also not centrally managed. And so I think that leads to why this is still such a problem at law firms, because the magnitude of the issue and the risk being assumed across the firm, gets overlooked. It's not able to be seen by any one single person across the firm. So just to exemplify this a little bit, you might have a case team, attorney one, we'll call them, over here in the IP world. The IP team might be using a tool like Snagit, a reasonable screenshot type tool, but not one that is easily authenticatable. Attorney number two over in the labor and employment side of things might need a capture made. They'll give that request to a paralegal and say, just go get it however you want to get it. That paralegal might print something to PDF. Pretty simple way to grab content off the internet. Attorney three, who's in litigation, might have a larger project, and so they might outsource to a forensic vendor who knows exactly how the forensic vendor is getting this type of evidence taken down, but hopefully they're doing it in a reputable way. But they're just outsourcing to their kind of golfing buddy there. And then attorney four, also in litigation, might say, hey, we actually have a practice support team who's helping out here. Maybe I should ask them, or the e-discovery team, to help me with this collection. And so, from where most private data goes, that's this practice support and e-discovery team. It's impossible for these attorneys to collect private data, emails, cell phone messages, things like that by themselves. And so these central support teams see a lot of that demand across the different case teams. In the public data world, there are just so many other different ways to essentially take screenshots that attorneys are just kind of slogging through it on their own. And the practice support team is really left in the dark. They're only seeing a very small fraction of the total demand for this type of work across the entire department. And again, all of these methods, especially these kind of screenshot methods where the attorney or their paralegal is in that chain of custody directly, is very dangerous and risky for all the reasons we just discussed. And so because of that risk, there have been firms, especially some of the largest firms in the country, who have adopted what I'll call approach two here. So that's a no collection or an outsource only policy. And so what this is an internal firm rule that no employee can make collections that will be then used in trial. And again, this goes back to all those risks we just talked about, but they don't want their employees to have to sign affidavits. They don't want their employees to ever need to go show up, sit on the stand, and testify in court. It's a distraction to the case. And I think a very, very sound theory and a good rule for firm collections. So advantages, I think the big one, obvious one, is it helps avoid some of those disaster situations in the case examples we discussed, because if you're outsourcing to a vendor who does this all the time, this collection is going to be properly authenticated, and you're not going to have any trouble getting that evidence admitted in court. I think there were definitely some unintended disadvantages or downsides to this that these firms understandably didn't kind of foresee. And so talk about them a little bit. The process of actually outsourcing every single collection to a third-party vendor is pretty logistically complex. It requires a back and forth with the vendor and a contract with that vendor each and every time a screenshot is needed. And so for the attorney who's just trying to make it through their case, do this research, that becomes pretty burdensome. It's also pretty slow to get collections done by an outsourced vendor. Often there's a big queue of jobs that they're working through, and so can take days to weeks to have a standard collection project completed. And that is often just too much delay to reliably make sure that sensitive content, something that might be taken down imminently, gets captured before it does get taken down or changed. And finally, it's expensive. Every capture tends to cost in the range of $500 and above, up to thousands and thousands for the more complex projects. And so this cost can add up. It's generally a cost that the attorney will be asking the client to pay. And the client might just say, no, like I don't exactly see how this collection is going to help the case. It's, my legal bills are adding up already. I don't want to add thousands more to it for, this collection. We're not going to do this. And so that, even though it's evidence that the attorney might think is valuable to the case, their hands might just be bound by the client's willingness to spend. And so some definite disadvantages to this no collection policy, although overall definitely in the right place, by trying to avoid some of these really massive risks that we talked about. Logistically, it becomes quite challenging to actually enforce in practice. And so what happens is that, the attorney might not necessarily follow the no collection policy each and every time. And yeah, here, I think, it's an unintended consequence of some of those disadvantages is that, this may not actually be a practical solution for each and every capture. Outsourced collections actually do work just fine when they're done alongside the rest of e-discovery work. And so that's in trial preparation, that's in much later in the litigation process. A forensic vendor might already be engaged for other types of ESI. And you can simply have them collect web evidence alongside some of that other private data that you're working with. But as online evidence becomes more critical, the very best attorneys are doing more web research earlier in the process. They're also recognizing the importance of capturing, preserving what they find as soon as possible because they know that content could easily be changed anytime. And this is really just so far away from trial that admissible evidence might not be top of mind, but at the same time, they're being told by their firm that they shouldn't make collections internally. Their support team is telling them they can't make a quick capture either, but we have to go engage this outside forensic vendor. We have to set up a contract. It's going to cost hundreds and thousands of dollars. And so what is this attorney going to do? They're probably going to get out the snipping tool on their desktop, and we're right back to the ad hoc collections methodology where everyone's kind of doing it themselves because unfortunately this no collections policy is just too cumbersome to comply with each and every time a capture is needed. And so approach number 3, this would be a self-directed tool that keeps the user out of the chain of custody. And most of this presentation was designed to be purely informational and educational. I will talk a little bit about PageVault today because to our knowledge, PageVault is the only tool on the market that actually keeps the user out of the chain of custody. And so what can a tool like this provide? With any capture that gets made, instead of just a simple screenshot that you might be commonly using, a legal grade tool, as we like to call it, can provide a number of things. One is a metadata cover sheet. And so this will be a very formal, presentable page that's very helpful for anything from depositions all the way to trial that provides some of that key metadata that everyone knows the court is going to be looking for, whether that be the capture URL, the IP address, the date and the timestamp, things of that nature. It'll come with an accurate capture that looks exactly like what you see on your actual internet screen. And this is important. I'm sure many of you have had the experience of printing a page to PDF and it comes out looking nothing like what you see online. And so this is definitely an important part of any online evidence collection process. And then finally, the affidavit. We've talked a lot about those today. The importance of having somebody who's able to provide those affidavits who's not an internal firm employee. And if the self-directed software tool can keep a user out of the chain of custody, then that vendor can actually be the one, that software vendor can actually be the one to provide affidavits on behalf of the firm. Takes a lot of the complexity out of the process, takes a lot of the risk out of the process as well. And so just to go a click deeper on how a software tool where your firm employees are self-directing that tool, they're making captures themselves, how is it possible that they're not in the chain of custody? And so we find a diagram here to be pretty helpful. So most web capture tools, as we've talked about today, are pretty simple. It's a web page, a web page server feeds the content, that capture tool downloads the content on the user's computer, just saves it down to their local hard drive storage device. And of course, that user is squarely in the chain of custody. It's as if they took that thumbprint on a glass back to their office and put it on their shelf. They have the ability to tamper with this evidence in any way, Photoshop it. Of course they wouldn't, but they could. And so, that user is in the chain of custody and would have to provide that affidavit and go testify in court if required. With PageVault, it works a little bit differently. And so we have the same web page server, we have the same user at Page Vault who's navigating through the tool, making captures on their own. But instead of that content downloading directly onto the user's computer, there's actually a Page Vault cloud computer that is a remote desktop. All the user is doing is remote viewing and control this Page Vault cloud computer. And so the content is not going from the web page to the user computer, but actually from the web page server to Page Vault's cloud computer and Page Vault's storage, AWS storage that's in the cloud as well. So this architecture is simple to understand, actually quite complicated. It's a patented architecture, and really just important for ensuring that that user's computer is actually not where any of this content lives. It's not that user is being kept at arm's length from the content itself. And so implication there, Page Vault's cloud computer, Page Vault as a company is squarely in the chain of custody, of course. Our CTO is the one who can provide affidavits that ensures evidence can be authenticated and admissible in court. And importantly, the user is actually kept out of that chain of custody entirely. Their hands are clean. They don't have to be the one to go testify in court if called upon. Okay, and then the final approach here, we talked about an ad hoc approach, every man for himself. We talked about a no collections policy where you're only outsourcing to the third-party vendor. We talked about an admissible legal grade tool that keeps the user out of the chain of custody so that a lot of those captures can be done internally, but still have the advantages of outsourcing, which is that that employee isn't asked to be on calls. That employee never has to take the stand or provide those affidavits. And then the final approach we'll talk about here is kind of a hybrid approach. That's where you have a self-directed tool in-house so that you can do captures that are where outsourcing is not a viable option. And you also have a trusted outsource partner who can help you with some of these collections. And so I like to think about the complexity of the collection project being the main determinant of what solution, what tool you use for these captures. And so if you have the graph here, made it a decreasing size bar because I'd say the vast majority of captures are very low complexity. They're easy. They could be done by a simple screenshot if you wanted to. It's a couple of posts. It's a web page, something like that. There are definitely projects where it's thousands upon thousands of very large social media profiles. Those are very high complexity projects. And then there's a lot, in the middle. I'd say the low happens on a daily, many times a day basis across law firms. The highs, the high complexity projects, happen once a month, much less frequently. But good to have a solution for, wherever your project falls on the complexity curve. And so our recommended approach, and firms will do this differently. There's lots of different ways that this can be handled and done, but our kind of recommendation for how we've seen firms, create the most free-flowing, effective process is for these really low complexity projects, these relatively simple screen captures, the case teams themselves should use the self-directed tool. They should still be using a tool versus a screenshot because they need to stay out of that chain of custody. But they can be equipped to actually make these captures as a part of their research process, so that they're not spending a ton of time, communicating the request to somebody else who's not as in the weeds of the case and not as familiar with what exactly the case needs. And so, an easy to use tool will be something that, an attorney themselves, a paralegal who works closely with the attorney can pick up in a matter of minutes and start making captures in a authenticatable way themselves. For these kind of medium grade projects where, might be a little bit more complex, might require expertise beyond what an attorney or a case team wants or has the time to actually go learn, we recommend developing a small team of in-house experts who are thoroughly trained on this self-directed tool to handle these projects. And these teams will often live, in an e-discovery department, in a litigation support department, somebody like that who sees enough volume of these types of projects on a daily basis where they get really familiar with the tool. They spend a good amount of time in training sessions, and they just know all the ins and outs of how to make these collections. And then finally, there are going to occasionally be projects that are so large and so complex that even with a self-directed tool, it might not be economical or even feasible to capture them in-house. And so outsourced vendors can be a big help here, saving time, for the internal team, lowering costs to the clients actually versus billable hour time spent internally. And so the Page Vault on-demand team can serve as this outsourced vendor, which would guarantee you consistency in output quality that you'll get from your self-directed tool. And so the exact same types of captures being created across this entire spectrum, just who and how they're being done can often vary depending on the complexity of the project. All right, so that is all the content I have for you today. A quick summary and recap of the main points here. If you remember anything coming out of this, it's these couple of points to take away. Number one, public or third-party ESI is growing in importance in litigation and investigations. And firms who want to stay ahead of the curve, attorneys who want to stay ahead, are developing strategies for how to collect and preserve this appropriately. Importantly, evidence should be collected early and often. The internet is ephemeral. It's changing frequently, and it's important to go ahead and preserve the internet, as early and often as one can. The federal rules of evidence dictate how collected evidence must be authenticated. And despite pretty clear guidelines and rules about this, attorneys are getting this wrong all the time. That could have pretty disastrous consequences, when that evidence actually gets ruled inadmissible in court. So why is this happening? I think there's two competing facts that make this process quite challenging. One is that according to the federal rules of evidence, firms should always avoid having their employees be in that chain of custody. But at the same time, the obvious solution to that, outsourcing all of their web captures to a third-party vendor, is often impractical. There's a number of captures where the complexity, logistics, or the cost of doing so would just be too high, and it's almost not worth the risk-reward trade-off for firms. And so, luckily, there is a middle ground. Firms can leverage a self-directed software tool that keeps users out of the chain of custody. And importantly, as you're evaluating tools, just make sure that the software vendor can and is willing to provide affidavits on your behalf. That's a sign that the tool is keeping the user out of the chain of custody, which is fundamentally important to your web collection process. Thank you very much. Please feel free to reach out to me directly anytime. My email is alex@page-vault.com, or go ahead and visit www.page-vault.com. There's a lot of helpful resources on our page, white papers, things that will delve even deeper than what we were able to cover today about the rules of online evidence and why it's important to get this right. Thank you very much.